Welcome back. Again, my thanks to the Journal for inviting me and including all these wonderful people who I'm looking forward to listening to. My name is Don Beskind. I'm on the faculty here. My relationship to this topic is a more recent one in that though I was a criminal defense practitioner here in North Carolina starting in the mid to late 70s for a while, I've moved away to civil practice but came back to this topic to argue the Racial Justice Act case in the North Carolina Supreme Court unsuccessfully, as is my wont when I'm arguing important cases in the North Carolina Supreme Court. But nonetheless came in contact with enormous data from the Michigan State University study of the North Carolina system, some of which has been addressed by other studies as well, and came away with an understanding of the dimensions of geography and race that are so obvious, at least in this state and apparently in others as well from the work that you're going to hear about. So we're going to start with Rob Smith and go from there.
This little light says this is on, but is it on? Wow, how about that? All right. Oh, it's also loud, it turns out.
They'll fix that for you.
Oh, okay, sorry. So last summer when Justice Breyer issued that dissent in Glossip versus Gross, he said the number of active death penalty counties is small and getting smaller, right? So he noted under over a 6-year period at the 2000 to 2006, yes, there are about 35 counties in America that averaged about 1 new death sentence per year, right? And we really care about death sentences because it's a sense of what's going, when you look at executions, it's this question of, are we actually getting what we say we're getting when we have this punishment, right? When you look at death sentences, the question is, where are the people today when they have a chance to inject directly, whether or not to seek a death sentence, the elected prosecutor, or return a death sentence, the jury? Where are we today? And so Breyer says, you know, the first part of the century, we have about 35 places, right? When he wrote his opinion, it was down to 15. Now, as we sort of move to the end of the year and see some drop-offs, we're at about 12 counties in America that average 1 or more death sentences over the last 6 years or so. And so this is what that looks like. And if you notice right here, California, there are 4 counties in Southern California, right, that account for more death sentences the entire Deep South does these days. In fact, one of those counties, Riverside, California, this year, had more death sentences alone than the entire Deep South. But the thing about them is they don't actually execute anybody, right? And so about a quarter of the death sentences in America this year, 49 new death sentences in America, right? A nation of 10 to 15,000 homicides a year, 49 new death sentences in the country this year. About a quarter of them are out of California or Pennsylvania, which also doesn't execute anybody. And about a quarter of them are out of Florida and Alabama, which out of those sentences, only 1 was returned by a unanimous jury. The rest of them are sort of a non-unanimous jury. So, you know, from Blackstone through the beginning of this country, sort of the common law tradition has always been unanimity. There are a couple states in America that allow non-unanimous death verdicts. Florida and Alabama are 2 of those places, and a quarter of the death sentences come from there. So you have about half of those 49 death sentences in America are places where no unanimous jury returned that death sentence, or else they don't execute anybody, and there's no chance anybody's ever going to get executed in the near future. So it's a very few number of death sentences. I think this really shows the picture, right? This is Texas. In 1999 had 48 death sentences. The United States of America this year had 49 death sentences, right? Last year it says 3 death sentences. There are really 2. What happened in the third death sentence, and this sort of previews something we'll talk about in a minute, is the person was so incompetent, or it seems to be mentally incompetent, and the judge had to continue sentencing, couldn't impose the death sentence because they're not sure the person was competent to be executed. So there's actually only 2 official death sentences in Texas this year. Harris County, Texas, right, used to have 10 to 15 death sentences per year throughout the 1990s. People called it the buckle of the death bout. Last year, 0 death sentences. So Breyer said, it seems fair to say that it's now unusual to find capital punishment in the United States. When we look in practice, what are elected prosecutors doing? Are they seeking the death sentence? What are juries doing? Are they returning the death sentence? Breyer says, and I think we've seen, that it's now unusual. And so then the question becomes, is it a cruel punishment, right? And on one hand, when we say it's cruel, we go back to what Professor Donahue said earlier today. Is it meaningfully contributing to some legitimate purpose of punishment? And even if it does meaningfully contribute to some legitimate purpose of punishment, are we sure that we can reliably, our system reliably only gets the people who are the worst of the worst? And what that means is both the people who've committed the very most aggravated homicides, but increasingly over the last 15 years, the court's made it clear that regardless of how aggravated the homicide is, it's also the people who have the most serious moral culpability, the people who have moral culpability that's significantly elevated from the typically developing adult. And we'll see how that matters in a little bit. But the reason why I'm drawing this out now is because when we say, is it cruel? I think the fact that it's so unusual helps to tell us whether or not it's cruel, right? Because if the punishment was necessary, if it was retributively necessary, if death was really the only punishment that somebody should get if they kill somebody, right? Then it's very unlikely that we'd only have 49 death sentences in the United States last year, right? That they would be so spottily applied and so geographically isolated. If it was necessary, it was much more likely to be routinely and regularly applied, right? But the question is, what do we actually know about these counties? So we say it's unusual, and we want to figure out if it's cruel, right? And so what do we know about the counties? Okay, let's look at the places and look what the death penalty looks like in those places. Maybe it's legitimate democratic variation, right? The people of Caddo Parish, Louisiana, they really want the death penalty. And they express that by electing their local prosecutor. That local prosecutor does their best. They ferret out the cases. They play by the rules. The defense lawyers build a relationship with their client. They get the mitigation evidence. They present it. The prosecutor rejects it. They go to trial. The jury hears all the evidence. There's a careful deliberation. There's no sort of extraneous factors like race. And they decide that the death penalty is an appropriate punishment in this case. And so there might only be 49 death sentences, and they might be really geographically concentrated, but it's legitimate democratic variation. Or maybe it's not, right? Maybe it's not. So we'll look. So I want to start with Caddo Parish, Louisiana, okay? Caddo Parish is a place that is one of the counties, it's second or third, I hear it differently and I can't quite remember, but it's one of the counties in America that had the most votes for George W. Bush, George Bush's father before that, right? These are places, this is a county that's very conservative traditionally, right? And so the first thing I want to look at is like, what are the ingredients of the death penalty, right? What are the ingredients of the death penalty in a place like Caddo Parish? And so the first thing I want to show is I think we have some overzealous prosecutors. In these counties like Caddo Parish, overzealous prosecutors. So Dale Cox is responding to a reporter who asks him, Glenn Ford was exonerated after 30 years, and the prosecutor who put him to jail, put him in the death chamber at Angola in Louisiana, said, I apologize. I was young. I was arrogant. I thought he was guilty. I ignored other evidence. And what I've learned over these years is we just, as fallible human beings, cannot really know whether or not somebody is guilty or innocent. And death is just too much to wager, right? And so a reporter went and asked Dale Cox, well, what do you think about that? You know, this is from your parish. As a prosecutor, used to work in your office. What do you think about that? And he said, I think we need to kill more people, right? Well, it didn't really strike people well, and so we'll see in a minute, it starts to blow up. But Dale Cox is also the prosecutor. He becomes the district attorney, but he's also the prosecutor who's responsible for 1/3 of the death sentences in Louisiana, the state of Louisiana, since 2005. If you actually talk about people who are on death row in Louisiana right now, it's about half of the death sentences of the people who are still on death row, but because of some reversals in other cases, 1/3 of the people overall sentenced to death since 2005, Dale Cox. One of these people is Rodriguez Crawford. He was 19. He's a young father, and he wakes up and the baby died. And the prosecution, Dale Cox, says that this is a murder, right? Well, the medical examiner in the case, the state's medical examiner, to be clear, says, I can't tell with an absolute degree of certainty that this was a homicide. All I can say is this is more likely than not a homicide than caused by the pneumonia the baby had, right? More likely than not, which I'm not, like you might think we should exercise a degree of caution in this situation, right? But Dale Cox tells the jury when he's arguing for a death sentence, Jesus demands that his disciples kill a child abuser by placing a millstone around his neck and throwing him into the sea, right? I think that's sort of the opposite of the caution that you'd expect somebody in that situation to argue. Later, he said, and I'm sorry for the language, when he got mad at the defense lawyers, I want to kill everyone in here. I want to cut their fucking throats. I'm just being honest, and if any of them want to go outside right now, we can do it. Dale Cox is sort of picked up all over the country, right? This really struck a nerve, and I think this is very different than the 1990s. I mean, it just tells you something about like where the country has moved, that it's not that people are cheering that Dale Cox is like, let's kill more people. People are horrified by it, right? It's almost every major newspaper and editorial board, but also more importantly, the local newspaper starts saying, this is embarrassing. Like Caddo Parish, they had the Chamber of Commerce folks writing saying, this is not good for the business environment in Caddo. This guy is out of control, right? So if you say, well, he's only responsible for a third of the death sentence, who else? Like, who else is in Louisiana? Well, if you add these two guys in, who are sort of like the dynamic duo, it turns out, together with Dale Cox, they're about 2/3 of the death sentences in Louisiana over the last 10 years or so. And so they actually used to work in his office. But it turns out that they applied to the Department of Defense to ask for more automatic rifles and machine guns and some armor and some random other things. And it was this really dangerous joint investigation with the sheriff's office. I mean, just very dangerous, very elaborate, state-of-the-art investigation. The only problem is it's totally fake. Totally fake. So they're getting these machine guns in, and the sheriff's like, yeah, no, I have no idea what's going on with these guys. It turns out they were also retrofitting their private vehicles with police sort of sirens and pulling people over. And so these are the prosecutors. So they're fired for Caddo Parish. You might think, hey, maybe the state bar is going to discipline them. Like, I don't know how many of you have taken, ethical, your professional responsibility class. I'm guessing like you don't learn a lot of that model behavior. But they don't discipline them. In fact, they're now roving around Louisiana as special contract lawyers trying capital cases for counties. And so when you add up their cases with Dale Cox, they're responsible for about 2/3 of the cases. One of those cases has already been reversed. But I want to tell you a really happy story because somebody said the tenor is really changing in some of these places. And if you just know more, if we politicians think that their constituencies really want the death penalty. Maybe that's not true. I want to show, this is a picture of a courthouse. Later on, you're going to see that there's something very different about it. There's no Confederate flag. That used to not be true. In 2011, there's a Confederate flag in front of the courthouse. I'll talk about that more later. It's gone now, and it's gone now because of the public attention that came to it. But more importantly, Dale Cox said, after the Confederate flag debacle, after he starts getting attention for his comments, he says, I've come to the position on my death penalty position as the minority among members of my community, and it's going to continue to be a source of controversy. And he stepped out of the election in Caddo Parish, Louisiana. And this man, James Stewart, became the first African-American elected to be district attorney in Caddo Parish, Louisiana, running on a reform platform about how people like Dale Cox went too far, were too excessive, and were out of step with the rest of the country. I think it's something very important to note about the impulse in America. This isn't Manhattan. This is Caddo Parish, Louisiana, right? So where else? Prosecutors, Duval County, Florida. You might remember Angela Corey. One of my favorite quotes about her is Sandy Dallenberg is the former president of the American Bar Association and the president of the Florida State University, one of the most respected lawyers by any measure in Florida, said Angela Corey, the elected prosecutor in Duval County, cannot command the respect of people who care about justice. All right, I think that's a major indictment. You might remember, she tried the Trayvon Morton, George Zimmerman case. She was the one, the misconduct allegations that are around that. She tried Marissa Alexander, the case where it's the warning shot. She tried and put her in jail. She tried Christian Fernandez for murder, the 12-year-old kid. I mean, all of the major controversies that come out of Florida, you tend to trace back to Angela Corey, right? She is responsible for more death sentences in Florida than any other county by far, right? One of her head prosecutors, a guy named Bernie De La Rionda, 27% of his cases have been reversed. He's personally obtained since 2008 11 death sentences. I think that's actually old. I think it's now 12 since he had a new one. The Florida Supreme Court, not the most liberal Supreme Court in the United States, reversed 2 of his death sentences, not because the guy was innocent or because there was like particular misconduct or because there was a jury selection problem, but because they said, you know what, this guy didn't deserve it. It was just too excessive for this particular defendant. 2 death sentences, Florida Supreme Court. They also reversed a third of his, a third death sentence for official misconduct. He put on evidence that he shouldn't have that the police obtained, and a 4th sentence in a non-capital case for improper comments to the jury. Bernie De La Rionda. Maricopa County, Arizona. 3 is an important number because that's the number of prosecutors who are responsible for 1/3 of more than 60 death sentences since 2007. This is one of them, Jeanette Gallagher. The Arizona Supreme Court has found misconduct in 3 of her recent cases. They called her inappropriate, very troubling, and entirely unprofessional. This is Juan Martinez, who won the Home Run Hitter Award for his behavior in capital cases from the National Prosecuting Attorneys Association. The Arizona Supreme Court has found misconduct in his cases. They called his behavior reprehensible. He's referred to a defense lawyer in the middle of court as Adolf Hitler and his big lie. He's badgered witnesses. He's committed sort of discovery misconduct. He said when it's not even worth going, you can literally spend all day talking about it. A relatively conservative journalist wrote a story called "An Army of Juan" that sort of spent a large amount of time explaining his misconduct. I think it tells you about everything you need to know in the title. You can go through and name it for any of these counties, and I won't spend time, but in Riverside County, you have 1 DA who has 8 death sentences. Judge Kaczynski, 9th Circuit earlier this year, called out from the bench in one of the Riverside cases and said, I want you to ask your boss, the Attorney General, does she really want to stick by a conviction that was obtained by a lying prosecutor, right? That's out of that office. And the elected DA said, I'm going to retry this guy. Yeah, I'm not concerned about it. We're going to retry this guy for a 3rd time after his lawyers put on fabricated evidence. Kern County, same thing. Almost all the Orange County has a scandal right now where they removed the entire district attorney's office because of an illegal snitch program that they've had. This is time and again overzealous prosecutors. So what about the defense lawyers? Let me give you some numbers. 1 in 5, that's the number of Louisiana death sentences that one guy, Daryl Gold, is responsible for in Caddo Parish. 3 is the number of times his law license has been suspended. I didn't put 14 up there because that's the number of times where he's been reprimanded publicly but not suspended. And the last time he was suspended, which I thought was incredible, is they said, you cannot represent paying clients. You can keep going with your death cases. That's cool. 75% is the number of lawyers in Caddo Parish who are, or number of cases in Caddo Parish since 2005 who had a lawyer who, under the new defense representation standards in capital cases in Louisiana that were certified last year, are no longer eligible to try capital cases. What about Duval County, Florida? This guy is elected, Matt Shirk. The prosecutor and they had joint election ceremonies. She called him his darling. She actually helped with the transition to the office. He's been indicted. It turns out, here's some free legal advice for you. Do not hire people from a strip club to come and be on your professional staff at work for the sole reason that you met them in the strip club, but if you're going to do that, because it's tempting. And so if you're going to do it, don't build a shower using public dollars in your office and have that. Doesn't work out well. But when he fires all of the experienced lawyers in his office, all the experienced capital lawyers, and he points this guy, Rafiq Eller, to be his main lawyer and his capital lawyer. Rafiq Eller is responsible for either 10 or 11 death sentences. I think it's the most in America since 2008 as a defense lawyer. The Florida Supreme Court has reversed him like 4 times. I'm sorry. That's a lie. They found that he was ineffective. He was ineffective 4 times. They've reversed him 3 times. The other time they said it wasn't prejudicial in capital cases. People have described him as it's like the person had no lawyer at all, right? There's actually 2 pending oral arguments in the Florida Supreme Court right now where they're ineffective assistance claims because he did no mitigation investigation in those cases. He's training other lawyers in his office. They're now putting out these motions across the office that are saying, I am not mentally retarded, and I don't want my lawyers to investigate that. And they're having their mentally retarded, like 70 IQ score clients sign those waivers. Maricopa County, Arizona, he looks like a killer, not a retard. That's not actually the prosecutor. That's the defense lawyer talking about his photo of his client who has a low IQ score. This is what he's responsible for. A number of people that are on death row in Maricopa County. This is what courts have said about him. He violated the rules of criminal procedure. He lacks candor, willful misconduct, offensive and incomprehensible motions. These are all in capital cases. Lawyers have written letters to a judge asking, please, I haven't seen my lawyer in over a year. Please remove him from the case. All right, please remove him from the case. But other people describe him as passionate and hardworking. He's very passionate, very hardworking. The problem is, at his other job as a football coach, okay? Because while he's representing all these capital clients, he was often unavailable to clients and co-counsels on most weekday afternoons during football season and always on game days, okay? What you don't see on here anymore is Virginia. Virginia has a statewide capital defender system. Let's just be clear. Like, no, this is not SCAD and ARPS, right? Like, this is a bare bones, minimal funded, like, decent representation. And death sentences in Virginia have just plummeted. If you look at Los Angeles County, California, about half the cases go to the public defender office. The other half of the case, 10% or so, go to an alternate defender. Neither of those offices have death sentences. Out of 60 or 70 death sentences over the last decade, they have 2 or 3 among those offices, maybe 4, right? The private bar that has about 40% of the cases has all of the rest of the death sentences. Why? Because they don't do mitigation packages. They don't meet with their clients. They don't you have the right to meet with the prosecutor. They don't do that to try to get mitigation because they're given their payment up front and then they're paid again when they go to trial. Same thing with Riverside, the county where I said more death sentence than anybody else in America this year. That office, you get 1/3 of your payment up front. You get 1/3 of your payment if you go to trial, and you get 1/3 of your payment when you finish the trial. So why in the world would you spend all the time necessary to build a relationship with your client and to develop the mitigation, hundreds, thousands of hours of work to develop mitigation to try to avoid a death sentence, to say this person's not morally culpable enough to receive a death sentence? Why would you do that? If you plea and you're successful, you lose 2/3 of your fee. And that fee is not small, it's like $100,000. The other problem, and I'll move through this very quickly, are badges of racial exclusion. Lynchings by state and counties. Caddo Parish is the number 2 lynching county in America, right? Up until 2011, 2012, the Confederate flag flew in front of the courthouse. You had one juror who came in after years of nobody saying anything. Guy who moved down after the sort of riots happened after the assassination of Martin Luther King, moved to Shreveport, never called for a jury, finally called. They say, can you be fair? He's like, yeah, I can't be fair. Because to me, that's one of the biggest symbols of racial hatred that's ever existed. And you call this a place of justice? And we have to walk through that before I come in. Place of justice. Prosecution's like, we're going to need to get rid of this juror. And the defense counsel's like, no objection. And he moves. But that juror comes and starts a local movement and is vocal, and it leads to the Confederate flag coming down about a year later. they do a study, like who is actually serving in the community. It's almost 40%, 50% African American. Who's actually serving? Well, like, you're 3 times more likely to be excluded if you're an African American juror than a white juror. Many of the trials have no African American jurors at all. And so what else about race? Dale Cox says, society is a jungle. That's why we need the death sentence. Society is a jungle. Weird thing to say if your population is nearly half black that you serve, right? Society is a jungle, and we need retribution because it brings a visceral satisfaction. Houston County, Alabama, another one of these hotspots. That's the police chief with the Confederate flag. He is in the Sons of the Confederacy. He named his own son after Nathan Bedford Forrest, the first Grand Wizard of the Ku Klux Klan. 82%, that's the number of black jurors that they've struck from capital trials in Houston County. 3, that's the number of times since 2010 that the Alabama Supreme Court, let me say it again, Alabama Supreme Court has reversed the death sentences out of that county for race discrimination. Clark County, Nevada, this is during oral argument last year, one of the justices says, this isn't the first time we've been to the rodeo with your office on Batson being the case about striking jury discrimination. I don't understand knocking off these 2 black women. You're so afraid of losing that you knock off African Americans consistently. Frank talked about St. Louis, Jefferson Parish, and Baltimore. You'll notice they're no longer on the map. Well, what happened in those places? They became more African American. They're sort of white flight suburbs of cities. They became more African American, and courts start calling them out on excluding all of the black jurors from the jury. So in St. Louis County, they had the postal gambit, and so they would strike all post office workers because post office workers tended to be African American, and so they would make things up like, they have to follow the rules so much. Like, we never know what they're going to do it was just absurd, right? Jefferson Parish, Louisiana, it was Snyder versus Louisiana, like referring to it as his OJ case, like striking jurors with ridiculous explanations. They had David Duke, the KKK leader, out of there. The Supreme Court strikes them down a couple of times, and it's done. Same thing with Baltimore County, right? So then the question is, if we have these badges of racial discrimination, we have overzealous prosecutors, we have defense lawyers, what's the output? That's the input. What's the output? So I'm going to speed through this because I know I'm out of time, but forgive me. Justice Kennedy said, to impose the harshest of punishments on an intellectually disabled person violates his or her inherent dignity as a human being. Okay? And the court has said you cannot execute a person who's intellectually disabled or a juvenile because as a class, they don't have the culpability. No matter how heinous the crime, do not have the moral culpability to deserve the death penalty. Yep. This is Caddo Parish, Louisiana. This is a guy named Corey Williams. When he was tried, this is before the rulings from the court on juveniles and the death penalty, 16 is how old he was at the time of the murder. 67 was his IQ score. The big kicker, though, is it looks like he's innocent. New evidence suggests that he's actually innocent. This guy right here, right, 18 at the time of the offense, right, 74 IQ score. You want to remember him. He has a case in front of the Supreme Court right now. Lamondre Tucker is his name. He has a Supreme Court case that's right now. His case was the last case tried in front of the Confederate flag in Louisiana. Dale Cox was the prosecutor in his case. This is a guy named LaDerrick Campbell. LaDerrick Campbell's 18 at the time of his offense. He had a 67 IQ score. The judge asked during trial, is this guy delusional? Okay. Brandy Holmes, another one of her clients, Caddo Parish, she was named after her mother's favorite drink while pregnant. She attempted suicide as a child after she was raped. She had fetal alcohol syndrome, major depression, organic brain damage, and post-traumatic stress disorder. There's the Kennedy's quote, is that true in Caddo Parish? So what about nationally? Who do we execute last year? Because that's who we actually execute. Robert Ladd, the doctors in Texas, by the state of Texas, called him rather obviously retarded. Texas executed him last year. This guy's out of Georgia. 3 doctors testified that Warren Hill, 3 doctors employed by the state of Georgia testified that Warren Hill was mentally retarded. Georgia executed him last year. Cecil Clayton was missing 20% of his brain, had an IQ in the low 70s, was paranoid and delusional. Missouri executed him last year. Juan Garcia was 18 at the time of the crime. He had a 75 IQ score. He was extremely abused as a child. And at his penalty phase, an expert testified that because of his race, he was more likely to be dangerous in prison. Then we had people with mental illness. Andrew Brandon's a decorated combat veteran of the Vietnam War. He had bipolar disorder. At the time when he was arrested, he was living in a mountain sort of shack with no running water, no electricity. People called it a marginal life. The state of Georgia found that he was 100% disabled. This guy, Raphael Holiday, had depression with psychotic features. They said that the experts said he lost all contact with reality. Kent Spruce, also in Texas, paranoid schizophrenic with psychotic features. Justice Kennedy said this in the marriage context, and I think it applies here. They ask for equal dignity in the eyes of the law, and the Constitution grants them that right. If people can't be executed because they're 17 or they have a 72 IQ score, I have no idea how we executed the people that we sentenced to death in Caddo or who we executed in the United States last year. And so the last question is, well, what about, we're getting people who maybe aren't morally culpable enough, but do we just get it wrong, right? And so this is Glenn Ford. Glenn Ford was the guy from Caddo Parish, Louisiana that we talked about, who was exonerated after 30 years. That's Caddo Parish. But last year, 4 out of 7, remember that number, because that's the number of exonerations last year, death row exonerations, that came from one of our active death penalty counties, right? Jefferson, Alabama, this is Anthony Ray Hinton, the Equal Justice Initiative in Alabama, exonerated him. Montez Spradley, ACLU Capital Punishment Project right here in Durham. That's Anna Arsenault, his lawyer, exonerated this year. They're both out of the same county in Alabama. Maricopa County with the terrible prosecutors and defense lawyers. This is Deborah Milkey. She was exonerated last year. And in Harris County, Alfred Dwayne Brown was exonerated last year. 4 of the 7. Most of the people are just in these handful of counties. And so I'll just put it back to you. Is the death penalty cruel?
Thank you. Next up, we're going to hear from Sherod Brown.
Sorry.
There we go. All right, good afternoon.
Did I say Sherod Brown?
Yeah, I appreciate the upgrade.
You know what?
To the Senate, to the U.S. Senate, I appreciate the upgrade.
I just realized that my wife and I have been having these conversations about who should be the vice presidential candidate for the Democrats.
It wasn't an offensive mistake, so that's why I didn't want to correct you.
Sherod.
And I will take campaign donations if you want to give them to me. No problem. So first, I do want to echo some of the previous presenters and thank the Duke Journal of Constitutional Law and Public Policy for the invitation to speak on an extremely important and timely topic. So today my talk is going to address patterns of prosecutorial behavior and potential death penalty cases in Georgia. And of course, we can't really talk about the death penalty without talking about Georgia, right? Nearly 20 cases that originated in Georgia have influenced death penalty policy and practice nationwide. So it's no exaggeration to say that Georgia is the site for some of the biggest triumphs and tragedies pertaining to the fair administration of the death penalty over the past 40 years. Now, I'm not going to have time to even briefly review this very robust history, but I do want to talk about 3 important cases, and even focusing on those 3 cases, I'm not going to have time to go in any great depth, but I do want to give you the upshot of those rulings. And so the 3 cases, if my are Furman v. Georgia, obviously case that has been referenced, 1972 decision, Gregg v. Georgia, 76 decision, and McCleskey v. Kemp, 1987 decision. Again, that had been referenced earlier today. So when we think about, in the Furman case, right, when we think about the legal challenges that have been posed to the administration of capital punishment, we can think about 3 types of error, and then again, the constitutional problems that they create. Arbitrariness and capriciousness. And again, these challenges have been brought under the Due Process Clause, and also the cruel and unusual punishment prohibition against cruel and unusual punishment clause, leave out discrimination and bias brought under the equal protection clause, and then disproportionality and excessiveness also brought under the cruel and unusual punishment clause. And then Furman, basically what the court said in summary is, right, if practices violate that are arbitrary, discriminatory, and disproportionate, they violate the Constitution. Now, the court didn't articulate precisely how it would define these errors, how these errors could be measured, but it did make clear that if the government is in the business of executing individuals, right, the death penalty needs to be reserved for the worst of the worst offenders, administrated fairly or not at all. All right? Now, it's important to emphasize that the majority in Furman expressed strong concerns about actual outcomes in death penalty cases. Actual outcomes, right? These were distributive justice concerns rather than merely procedural justice concerns. And this was evident because just the year before Furman, in the companion cases, McGalta v. California, and another case called Crampton out of Ohio, the court basically said that the absence of sentencing standards, and then there's another issue about unitary guilt and sentencing trials, but the absence of these standards didn't violate the due process clause, right? So although the absence of these standards didn't violate the due process clause, right, there was still an Eighth Amendment violation because the outcomes of punishments themselves could be arbitrary, right? So now 4 years later in Brigg v. Georgia, the Supreme Court approved Georgia's revised death penalty statute in response to Furman, and that statute was actually signed into law by then Governor and former U.S. President Jimmy Carter. And this statute allegedly held the promise of eliminating or at least significantly reducing the rampant arbitrariness, bias, and excessiveness that plagued the administration of capital punishment in Georgia. Now, Georgia's capital punishment statute was expressly modeled after the American Law Institute's model death penalty statute. Now, those of you who I remember your criminal law class, the ALI was responsible for creating the model penal code, all right? Under Georgia's new statute, there were 10 aggravating or special circumstances were developed, but no specific mitigation circumstances, right? Mercy factors were specified. And once a jury found at least one aggravating circumstance, it was required to weigh all the aggravating evidence and mitigation evidence when determining whether or not to impose a death sentence. The jury was required to be unanimous, right? And the sentencing recommendation was binding on the judge. There was also mandatory, non-waivable, so that mandatory review of all death sentences to the Georgia Supreme Court. And what the court was supposed to do was determine whether, among other things, whether or not the imposition of a death sentence was influenced by any prohibited arbitrary factors and whether or not it was proportionate to not only the factors of the crime, but also the background of the defendant. Now, many states followed suit after Brigg, and then some companion statutes out of Texas and Florida were also approved. All right. Now, critics of these post-Furman statutes raised two key objections. So the first objection was that these revised statutes were based on an unsupported belief, right, that this heightened procedural regulation approach would produce the desired result, and that it would satisfy the Eighth Amendment. And even assuming for the sake of argument that it can, and we'll just assume that now, there was no evidence put forth by these states or even an independent party to support whether or not the statutes could actually do what they, again, purported to do. Even the American Law Institute, again, that established this model death penalty statute that the Georgia adopted, said that this was an untested innovation. All right. But the second criticism that was more central to my paper here was that these new laws were incapable of ensuring that the constitutional administration of capital punishment because they merely shifted discretion. All right. They merely shifted discretion. There was some now constraint on judges and juries with respect to the imposition of the death penalty, but still prosecutors had basically unfettered discretion with respect to charging and plea bargaining, and governors and boards of pardon and parole had unfettered discretion with respect to their clemency decisions. Now, in the oral argument, actually in Brigg, then Chief Justice Warren Burger commented, right, that front-end discretion and back-end discretion were inevitable features. And basically, right, if you took these criticisms to their logical conclusion, no capital statute would satisfy the requirements of Furman. However, Justice Berger really, I think, misunderstood what the criticisms were. The underlying point was that the revised statutes were insufficiently robust to really implement the heightened reliability requirements that the Furman court demanded, right? So again, potential abuses of executive branch power, again, whether it's on the front end with respect to charging and plea bargaining or on the back end with respect to clemency, could be monitored and, then when appropriate, remedied. And that's something that the court did not require in Gregg, all right? So again, arguably, right, our equal protection clause would demand this type of monitoring. So again, the title of my paper, again, Unregulated, this missing mandate of Gregg v. Georgia. The missing mandate was the requirement, one of the missing mandates, should I say, was the requirement that these capital charging decisions be subject to regulation, okay? Right, arbitrariness, discrimination, excessiveness, right? It's not just an issue of sentencing, it's also an issue of charging, all right? And given the fact that the vast majority of cases, both capital and non-capital, are still disposed by plea bargaining, right, and particularly in this homicide context, right, it's the exception rather than the rule that judges and juries are actually in a position to make these life or death decisions, right? So we think about the use of the death penalty, right? It's used a lot in leverage in plea negotiations. This has been well documented, and recent evidence suggests that the threat of the death penalty decreases the likelihood of a trial, so increases the likelihood of a plea bargain anywhere around 25%, right? But using the threat of capital punishment to obtain these plea bargains for leverage is problematic on moral, financial, and even constitutional grounds. And again, I'd be happy more to talk about that in the Q&A. As Professor Donahue mentioned, right, in the nearly 40 years since Gregg, we have this voluminous empirical literature that has documented widespread arbitrariness, discrimination, and excessiveness in the administration of the death penalty. Sadly, members of the court over this time, many members of the court have de-emphasized Furman's strong concerns about actual outcomes of death penalty cases, right? Focus more on procedure, but not actual outcomes, right? And have refused to test whether Gregg's assumption that these guided discretion statutes would result in accurate and consistently imposed sentences, okay? Particularly evident of this the shift in the court from outcomes to actual procedure was in McCleskey v. Kemp, again, another case out of Georgia in 1987, and as I mentioned before, that was based on a comprehensive study of death penalty charging and sentencing behavior in Georgia. And essentially what the study found was that there were strong racial disparities with respect to both charges and death charges and sentences. But the court would dismiss this evidence because it could not prove intentional discrimination in an individual case. All right? So again, in the span of roughly 15 years, we go from mandating the death penalty must result in non-arbitrary and non-racially discriminatory outcomes in Furman to holding that statistical evidence of these arbitrary and discriminatory outcomes was insufficient to succeed on the claim. All right? But we also know in recent years, both former and current members of the court have repeatedly signaled that the constitutionality of the death penalty hinges on its non-arbitrary and non-discriminatory application, and that statistical evidence demonstrating the persistence of these problems should support, right, cognizable claims, right? Obviously, with Glossip v. Gross case, this is mentioned very heavily in, featured very heavily in Breyer's dissent. All right? So, one of the things that Breyer says is he emphasizes again the importance of not only the evidence, but also continuing to develop this type of evidence. You could think about it as a clarion call and with respect to challenging the administration of the death penalty, and so I've attempted to partially answer that call through examining recent capital charging and sentencing behavior in Georgia. So we're going back to numbers now. I know a lot of you went to law school because you didn't want to do a lot of math, but we're going back to the numbers. Now, I've tried to augment the numbers with pictures, all right? So hopefully those of you who don't want to ignore the numbers and then look at some of the pictures. All right, so first let's just kind of translate some of the court's language, because I said one of the problems with Furman, there was kind of imprecise definitions of what these key concepts were. So how do I try to kind of operationalize these different concepts? So we could think about, again, validity, rationality, right? In order to be non-arbitrariness must be valid, it must be rational, and the way that I define this is the degree to which theory and evidence support the interpretation of legal decision makers, right? We can think about, again, the significant explanatory power of legally relevant factors. This definition has been pulled from cases in the non-capital context with respect to the rationality of legal decision making, okay? Interesting, right? So in non-capital context, we can have courts to give us precise definitions, but not in the capital context where the stakes are so high. We can think about consistency as well, another feature of non-arbitrariness, the degree of stability of legal decision-making across prosecutors. And then we think about unbiasedness would be the degree to which prohibited factors are unrelated to legal decision-making. So again, that's the way we want to operationalize these different concepts. What I do here is I collected data on every murder conviction in Georgia from 1993 through 2000. Actually to 2004, but I just focused on the data going through 2000 to examine death penalty charges, charging practices. Again, these are murder convictions, and I focused just on murder cases that resulted in murder convictions because, I guess I was supposed to stay close to the mic, as a proxy for strength of evidence, all right? I focused on post-1993 cases because that's when Georgia's life without the possibility of parole legislation was enacted, and that's important because at the time, it's since changed, I think, in 2005, but at the time, the death penalty, life without the possibility of parole was only a sentencing option in death penalty cases. Okay, so that's an important feature there. That's why I focused just on post-1993 cases, because then that incentivizes aggressive capital charging to get life without the possibility of parole. All right, so during this time, there were about 1,900 murder convictions, and about a little over 1,200 of these cases were death eligible. There were also 400 death notices filed during that time. You have to worry about all these numbers, kind of these proportions of the different variables that I examined, okay? So I won't be spending time on this graph, but just to let you know, there are actual numbers here behind the pictures. Map of Georgia here, you have some different colors here. So Georgia has 159 counties, all right? But they're organized into 49 what we call judicial circuits. And so you can see some of the thin black lines that outline the counties, and then the clustered color areas outline the different circuits. We also have something called judicial districts, but that's just an administrative thing. It doesn't really influence kind of the day-to-day operation. So a lot of the counties are clustered into circuits, particularly just when they're small counties. And so you'll have one actually prosecutor for that circuit. And the large counties, Fulton counties that you're in Atlanta, and some suburban counties as well, one county comprises the entire circuit there. All right. So if you can look at the distribution of death notices, for the judicial circuits, you'll see here, obviously, there are some circuits that have a lot of death notices here. I'm not controlling for population size here, just the number of notices, and then here again, the percentage of death notices from the state there. And so when we think about it, it's at 400 death notices, about 96%, I'm sorry, it's so low right here. I'm shooting Rob in the back of the head with my laser, but 96% of the judicial circuits did file at least one death notice in the time period. All right, so just want to focus on key variables. So distill that slide, that long list of variables until to the key variables motivating the study, right? So the first idea is kind of the legal core of the case, right? Right, then we think the really legally relevant case, number of statutory aggravating circumstances. I looked at them individually and also just combined them into a composite score. Number of defendants, number of victims, prior and current felonies, prior violent felonies, type of weapon used. Again, these are the legal core of the case, things that we think statutorily or just a matter of good practice should matter. And then we also have some quasi-legal factors, right? Maybe not legal, some clearly not legal, but we think about it, right? Defendant and victim age, again, we said to be relevant, right? Defendant victim prior relationships, defendant education, defendant employment, that's a little suspect. Defendant's number of children, defendant marital status, clearly impermissible factors, obviously. Defendant victim race. We go think about, well, gender, geography, election cycle, like, well, probably clearly impermissible, but some might disagree. All right. So again, what are these key concepts I talked about? How do we operationalize them? What do they mean? So again, we talk about validity, rationality, the degree to which evidence supports the interpretation of legal decision makers, right? Again, validity, rationality, we can say accuracy. All right. So let's think about how much are these legally relevant factors and some of these quasi-factors really explaining variation in charging decisions, right? So I said legal relevant factors only explain a small portion of the variation in charging decision, both within and across jurisdictions, right? So here's the full model as all the variables I listed here. Only 44% of within circuit variability in charging is explained, right? And 21% of between circuit. And what I mean by between circuits just look like kind of the aggregate factors in the cases. Do they explain differences, right? Or just some circuits themselves just have more aggravated cases, right? So again, what we look here is only 21%. When we look at the trimmed model, that's just the legal core. You see again, only 31% of within circuit variability explained, only 11% between circuit variability explained. Again, not appearing to be particularly rational process that's influenced by what the statute said should influence culpability of defendants. All right, now move on to the next concept here. Remember, consistency, reliability, the degree of stability in legal decision making across prosecutors. All right, now we get to some pictures. Hopefully, again, for those of you who tuned out on the numbers, you tune back in on the map. All right, so here's the probability of receiving a death notice. Again, that varies by circuit. Unadjusted, I'm not controlling for any of those factors here. I'm just looking, again, at probability. Again, cases could differ. I'm not taking that into account. I mean, differ along important lines. I'm not taking that into account here. What I'm just saying is, let's see this variability, the probability of receiving a death notice for cases that are death eligible, okay? You see huge variation, right? On the low end, you say as it gets darker, higher probability, right? Interesting here, Fulton County, or Atlanta was mentioned earlier, I think Professor Baumgartner, right? Fulton County, right? Not a necessarily high probability of a case receiving, a defendant receiving a death notice, a death eligible defendant receiving a death notice. You look at some of your suburban counties, much, much, much higher. But again, these are unadjusted. I'm not taking into account what could be important differences between the cases, right? Here's another representation of that graph, okay? What we have is this red line. This is kind of the state average, the statewide average, and then you see how the different jurisdictions vary, or I say a lot of variability there. I think these are the specific names of the circuits. We don't need to worry about those names here, but I will say, we look at here, let's look at Fulton County around here real low. All right, now what happens when we take into account, again, important case characteristics? Again, huge variation here. So again, how are cases that, and we adjust that are factually similar now, factually similar cases, how is a factually similar case treated across the different circuits here? Again, huge variability, huge variability here, right? So even when we take these factors into account, a lot of regional variation. Another way to say it is not a lot of consistency. Not a lot of consistency here. All right. Again, here's another way to similar graph before, statewide average. Once we take the factors into account for how that case would be handled, then again, variation based on these circuits. It's helpful then to maybe superimpose one over the other, the adjusted and the unadjusted, to see like what do these factors really give us? What are we really gaining? As I said before, when we think about the accuracy, rationality, these factors weren't helping us explain a lot of the variation. But again, we look at here adjusted and unadjusted. What I want to quickly point out is you would hope, right, once you take into these factors into account, they would kind of more shrink towards the statewide average, right? They would shrink, they would condense to the statewide average. You see some do convince, so like if these line up, this would be for the same county, unadjusted and adjusted. Some do move, and so you'll see the green circle closer to the county. Some actually, the unadjusted circle is closer to the county as well. So you even see greater inconsistency once you take into account legally relevant characteristics, okay, of these cases. I don't know if I want to spend too much time with this. These are other different consistency measures that one could take into account. that measure, again, levels of consistency. So this one, this is a measure of inter-class correlation coefficient. It captures a consistency one would expect if a prosecutor was randomly selected from the population and her charging decision was compared to the average charging decision of the prosecutors. Again, how similar would it be, right? Something 70, like similar to 70% of the other prosecutors in terms of seeking a death sentence in that case. That's considered good, right? 0.7, 70%, right? Here, roughly 0.2. That's total. And then interesting, when we break it off between white victim and non-white victim cases, you see even less consistency in the non-white victim cases. I'll talk more about race, but again, that's something I want to do. I know my time is a little bit short. These are some other measures. We won't worry about them, but they basically confirm this here. I'll say something real quickly about the median odds ratio. Basically, what that is going to capture, it encapsulates the risk that would occur if a particular case moved from one context to the other. So like on kind of median, what's the odds, right, that your case, increased odds that a case will receive the death notice when you move to the average, moving to the next higher level, and again, about twice as likely to get the death notice. All right. In practical terms, we could use the model I created to make some predictions. All right. So I said here, kind of regional inconsistency. If you think about the predicted number of death notices filed against defendants, if the average level of punitiveness is similar to, and I pick specific circuits. So basically it's saying if the whole state was like this particular circuit, okay? So we picked Cobb Circuit. This is in the 5th percentile in terms of kind of regional punitiveness, if you want to think, right? How aggressive prosecutors are seeking the death penalty in that county. And you'd say, again, remember the actual number was 400. Here you would have 274, again, a lot less in the low punitive county. Just here when we think about the 50th percentile, it's for 13. Now, the reason it's not necessarily 400 because the district we're talking about the median as opposed to the actual mean, for those of you who care, but the fact that it's not 100, it's exactly 400 doesn't matter. And then we can think about Griffith Circuit here. Again, very, very punitive county, we have 681. So that means if the entire state was like Griffith Circuit, we would have 281 more death notices. All right, quickly I'll talk about unbiasedness. This is when we get to the race issue as well, degree to which prohibitive factors are unrelated to legal decision making. And there's some studies. John talked about his study earlier. Again, this is the odds ratio. All right, what are the odds, increased risk of a death notice, considering based upon the race of the victim here. Here's white victim cases here. So if you look, right, this was studying in Colorado. What you see is when the study was, what's the odd ratio, the jurisdiction, the sample size, and the year studied. So again, what you see is in the Marceau et al. Study, that was odd rate of 4, so 4 times is more likely that a case that are factually similar on other relevant dimensions receives a death notice. John Donahue study in Connecticut, 2.3. The Baldus study that was referenced before in Georgia, 3.1. What I find in Georgia, again, roughly same sample size as Baldus, but obviously different time period. It's gotten a little better, and again, you can see other jurisdictions as well. All right, I won't spend a lot of time here with the descriptive statistics, but this talks about the different distribution of race based upon defendant and victim and racial combinations. But again, this is just the numbers in the data. What is important is this, okay? And this is adjusted predicted probability of death notices. So again, I take into account those legally relevant factors, and what would we expect what's the probability, the likelihood of receiving a death notice based upon these combinations. What you know is, regardless of defendant race, right, if your victim is white, much more likely to receive the death notice. What you'll see here, interesting for the case of Latino defendants, higher probability across all different victim racial combinations, but there were only 20 in the sample, so you can't really draw too much from that. When we look at the race of victim effect, again, this is the the impact of a white victim case on the probability of receiving a death notice. Again, here you can say you can increase. Again, this is for adjusted here. It did say adjusted here. The increase is it can increase the probability as much by 40%, or in some kinds decrease by less than 6% as well. That's the same type of graph mentioned before showing the variability with the race effect across the different circuits. I keep saying county, but I mean to say circuit. Again, to make this a little more tangible, we think about when we look at the different racial bias distributions across the different circuits, would be the predicted number of death notices filed against defendants if the race of victim effect was similar to, and again, breaking it down by the counties that seem to have a very strong race of victim effect and a very weak race of victim effect as well. And what you say again, remember the actual number was 400. What we see if the whole state was like the Daugherty Circuit here, we'd have 259. Again, roughly 400. If we had a county that was representative of the statewide average, and then on the most punitive, we'd have 505. So again, 105 more on those in those different jurisdictions. So last thing I'll say, where do we go from here? Right? Can our capital punishment system be fixed? I don't know. All right, I doubt it. But what I will say is, what can we do with the information that I have, that I've presented in terms of at least trying to repair it, and if abolition, at least in the near future, is not possible? And we could think about, how, right, again, answering Justice Breyer's clarion call, what could we do with respect to charging? One, we can think about greater systemization, normalization of data collection and analysis. Right, again, like a nationwide clearinghouse, what variables are important, how do we collect them so we know the information that we have is reliable. Like I said, stronger focus on the front end screening, focus on charging is important, right? Central role of empirics and case level assessment. That's something I can't talk about here because of time, but you could actually use these in case by case assessments as well. So prosecutors and defense counsel, they can say, listen, this is a case that does not appear to warrant a death notice. And again, in coupling this front-end review, this screening, with financial, administrative, and reputational incentives, right? So it actually has some bite for prosecutors. Sorry for talking too fast. A lot I needed to get through. All right, thanks.
Thank you. Next up is Lindsey Vann, who's going to talk to us about work that's been done in South Carolina by Lindsey and her colleague John Bloom and others from what used to be the Resource Center and I guess is Justice 360 now.
Yes, we've changed it. We decided starting our name with death was not a good way to get donors, so we're a little more upbeat now. So we're working for justice. I'm sorry that my co-author could not be here. You're missing a treat. He's wonderful to listen to, but I will try and keep our empirical analysis interesting. I promise I have no regression statistics.
Thank you.
So why is South Carolina important? I went to a conference earlier this year and somebody said, well, you're not a high-use state. And I said, well, it feels like it. You know, I'm representing all these clients on death row. But Justice Breyer, in his dissent in Glossip, did count South Carolina as one of the 11 states where the death penalty is not unusual. And so, you know, obviously I care about South Carolina because that's where I work, but it is an important state for this debate. So we've gone over this. Furman and Greg promised that there is reliability, that there is not arbitrariness in the system. And then, so all the death penalty statutes are deemed unconstitutional. South Carolina reinstates it. First, they go with a mandatory statute that's declared unconstitutional in Woodson, and then they model their death penalty statute after Georgia, and so we have very similar protections to what Georgia had in Greg, that the aggravating factors are supposed to narrow, that you consider mitigating circumstances, the bifurcated trial, and automatic review with a proportionality analysis. We've already talked about this also. Since Furman, there have been limitations on the death penalty. It's supposed to be reserved for the worst of the worst. That is not just the worst crimes, that is the worst offenders, so only major participants in the murder. There are no executions for intellectually disabled or juveniles. And then there have also been attempts to limit other types of arbitrariness in racism, and also by making sure that race is not considered by the jurors. And then Glossip, we've obviously talked about this. There are Breyer has 4 different things that he sees are issues with the death penalty that he thinks make it cruel and unusual, serious unreliability, arbitrariness, and the long delays. Those all make it cruel. And then that the use of the death penalty throughout the country has generally been abandoned, makes it an unusual practice. And so in violation, he thinks, of the 8th Amendment. So we decided to check out how South Carolina stacks up against those 4 things that Justice Breyer sees as important. Sorry, this thing. I'll give you just a little bit of an overview of South Carolina to kind of set the stage. We currently have 44 people on death row. They are all men. 9 of those people, as of today, have had their sentences overturned by a reviewing court. We still consider them as on death row because their grant of relief has either been appealed by the state to a higher court or they are awaiting a resentencing trial. So there's a chance that they will remain on death row. They have been there for an average of 14 and a half years. We've had 181 individuals sentenced to death since Furman, and the reinstatement, 180 of those have been men, only 1 woman. Her sentence was overturned, and she is now serving a life sentence. The race of the defendant, it's about 50-50 white and African American, but what's important is that 81% of the people who have been sentenced to death in South Carolina were sentenced for killing at least 1 white victim. Executions, we've had 43, all men. 10 of those were volunteers, so they waived their appeals. We have the 9th highest execution or number of executions in the country. And this is just some information about when the executions have happened. Luckily, we haven't had one since 2011, and that was a volunteer. The last non-volunteer execution was in 2009. Most of our cases are tied up in the appellate process. So looking at Justice Breyer's factors, the first is the lack of reliability. He looks at the outcomes, the actual outcomes of death cases. So in South Carolina, it is much more likely that a death sentence is going to result in a life sentence or even less than a life sentence after it gets reversed on appeal. So 47% of the cases that were originally sentenced to death have resulted in something lower than death, and only 24% of the people have actually been executed. Justice Breyer talks about innocence. We have 3 people who their cases were reversed and then they were later acquitted of murder. And then we also have some cases that I think nationally are starting to be tracked of people who have not officially been exonerated, but they have serious information about their innocence and that they have either had reduced sentences or they've been released based on information of their innocence. So, for example, this is Edward Lee Elmore. He was featured on Death Row Stories. He took an Alford plea to avoid being, the chance of being resentenced to death, even though there is significant evidence of his innocence. And then Justice Breyer says that error involving innocence isn't the only issue with reliability. There's also the issue of reversals. And so any case where there has been a constitutional error or some other sort of error in the case resulting in reversal is another sign of unreliability. So in South Carolina, similar to the rest of the country, we found that 60% of all death cases have resulted in a reversal at one point or another. This shows you a little bit of where that happens. 81 of the cases were reversed on direct appeal by the South Carolina Supreme Court. 42 of the cases have been reversed by various South Carolina courts in post-conviction review. So there is a lot of actual good review going on in the appellate courts within South Carolina. This is a little different from other states around the country where you're not getting relief in your own state reviewing courts. Although we don't get much relief in federal court. We are in the Fourth Circuit, which is a court that is very unlikely to grant relief in state death penalty cases, and so we think those numbers would be higher if we were in a different federal circuit. 86 cases have resulted in less than a death sentence when they've gone back after they have been reversed. So we research and shows the different types of errors that have been found in these cases. Most often it is some sort of an instructional error by the judge during the trial. There's also prosecutorial misconduct that has been found in 29 cases, and just general evidentiary errors in 42 cases. So those are the highest type of errors that are found. But then in post-conviction, there is obviously ineffective assistance of counsel. That is a significant reason for overturning death sentences. We've also had 8 people who were removed from death row based on later Supreme Court decisions. So the Atkins decision said that intellectually disabled could not be executed, so that removed 4 people from death row, and then there were 4 juveniles on death row at the time of Roper, and so they have been since removed from South Carolina's death row. Importantly, one thing that has never been found as an error is the South Carolina Supreme Court, though they are statutorily required to review proportionality, they have never, ever found a death sentence disproportionate to the crime. This is largely a result of the fact that they only review death cases when they are doing their proportionality review. So they have this pool of cases where they are looking at other cases that have received a death sentence, and if they can find one that's kind of similar, they say it's not disproportionate. But they're not looking at similar life cases where a defendant has not received a death sentence. And so one of our justices noted in a footnote that maybe they should reconsider that, because it largely is a self-fulfilling prophecy. If you're only looking at death sentences, you're almost always going to be able to find a similar case that has received a death sentence, and you're always going to find it proportionate to the crime. We also have never had a governor grant clemency in a death penalty case. No other state has executed so many people and had no grants of gubernatorial clemency. So, we have a good Supreme Court, I guess, in some situations, but they're not quite doing what we need them to do. So the next thing that Justice Breyer considered was arbitrariness in the sentencing. So we reviewed the race of the defendant and the race of the victim. You can see, consistent with some of the other statistics that have been up here, the people are generally sentenced for killing white victims. So we have white defendant, white victims is 46%. Black defendant, white victims is 34%. And then you'll see that only 18% of the cases are from black victim cases. But our research shows that 48% of all murders in South Carolina include black victims. So again, we haven't run all of the statistical regressional analysis that the other speakers have run on their cases, but this is definitely a significant difference that we've noticed. Gender also has an effect. Only 22% of the murders in South Carolina involve a female victim, but 53% of the death sentences are from female victim cases, and 58% of the executions involve a female victim. Then if you take the race and gender of the victim into account, it makes even more of a difference. So this chart might be a little difficult to read, but what it shows is that so on this side, on the left side, are the percentage of murders that involve that type of victim. So there are 48% of murders in South Carolina involve a white male victim. But then only 8% of the death sentences involve a white male, I'm sorry, did I say white? Black male victim. 48% are a African-American male victim. Only 8% of the death sentences and 9% of the executions are black male victim cases. Whereas 11% of the cases are white female cases, victim cases, and then you have 42% of the sentences and executions end up being from a white female victim case. Geography also plays a significant role in South Carolina. As you can see, we have 2 counties that are overproducers of death sentences together, they account for more than 1/4 of the death sentences in South Carolina since the reinstatement. And then we have 10 counties that have never had any executions or any death sentences, and a number that have had only 1 or 2. So we wanted to know why this disparity, and similar to what Rob found and has talked about earlier, we found that it comes down really to specific solicitors. So my favorite example, I guess, is the 11th Circuit solicitor, whose name is Donald Myers. He is the solicitor in the circuit that contains Lexington County, which I showed you on the last page, has the most death sentences of any county in South Carolina. He has obtained 39 death sentences, which accounts for 17% of all death sentences in South Carolina. He also is the most reversed prosecutor in South Carolina. 18% of all reversals in South Carolina have come from his office, and he personally prosecutes all of them. Also important about him is that he has been in office since 1977. So he has been reelected every 4 years to represent the state in Lexington County and the surrounding counties. And so he has personally made the death penalty decision, the noticing decision, on every single death case in that county since 1977. Like I said, he has the highest reversal rate also. Just some of why that is, it's mostly or largely prosecutorial misconduct. He often makes inappropriate comments during his cases that result in reversal. There was a child murder case where he actually wheeled a black shrouded baby carriage into the court during closing arguments and reenacted the funeral. The Supreme Court of South Carolina says you can't really do that. That's inappropriate. I'm actually representing a defendant from one of his cases where he called the African-American defendant King Kong, a caveman, a beast of burden, all during his closing argument. We've also discovered that there was a juror that called my client the N-word who was sitting on that jury, so he was probably very receptive to those racial comments by the solicitor. So the sentencing rates for these, we tried to control for, like, is this an effect of the fact that there are more homicides in that county? And similar to Professor Baumgartner, no, it is not. His sentencing rate is 6.8 out of 100 homicides. The average for South Carolina is 1.96 out of 100 homicides. So he's way over the state average. And then we found some other solicitors who are similar. And it was kind of interesting in our paper, we go into this in a little more detail. The other solicitors that we reviewed, they were not in office for all 40 years since Furman. And so we saw there was a significant drop in the death sentencing rate in those counties after they left office. So one thing that Breyer does not really discuss, but we feel is important, is the narrowing requirement. The Constitution requires that you narrow the pool of offenders who are eligible for a death sentence. In theory, the aggravating factors that are part of the statute do that. In South Carolina, they started out, the statute in 1976 had only 16 aggravating factors. It's now up to 22. And the South Carolina Supreme Court has interpreted some of these very loosely. So, for example, kidnapping is any movement of somebody or restraint of somebody by force, any. So almost every armed robbery case can also carry a kidnapping conviction, or any time that anybody is restrained includes kidnapping. So we see a high number of kidnapping cases that might not actually seem like a kidnapping to the lay person. And so we've done some studies in South Carolina where we've looked at every single homicide in a particular county, and we've done this in Charleston County and Richland County, which are two of the larger counties in the state. And when we've done that, we've found that when you look at these aggravating circumstances, 76% of all homicides are death eligible. So we feel that it's not actually narrowing the pool like is constitutionally required. Justice Breyer talks about excessive delays. As I said, the people who are on death row now have been there for 14 and a half years. The 2 longest serving inmates have been there for over 30 years. And then there are also long delays between the original sentence and the execution of the inmates. As a result, 9 people have actually died of causes other than execution while they were still on death row. That's 5% of everybody who's been sentenced to death actually dies of another reason other than execution. And as Justice Breyer pointed out, this causes a lot of harm to the individual inmate. In South Carolina, that's true also. Our inmates are all in solitary confinement. They are confined for 23 hours a day. And as a result, we see a lot of mental illness or aggravated mental illness on death row. We've done a study at my center where we found that 70% of all the people on death row suffer from some sort of severe mental illness. And so next we'll move into unusual. Justice Breyer talks about the decline in use in the death penalty. So as I said, South Carolina was counted as one of those states that is not unusual. But if you look at South Carolina, you really see a significant decrease in the use of the death penalty, and it's becoming much, much more unusual. So in the last 5 years, we've only had 2 new death sentences. That's down from, high in the 90s of 15 in a year. Again, this is not just, based on the homicides. So the rate of sentencing has also decreased for all the years that we have information for. And then the executions obviously have also decreased. So our observations are obviously that it is still arbitrary after all of these years. No matter what, over the 40 years, all the tinkering with the machinery of death really has not worked. And so we think that the only way to really resolve this is abolition of the death penalty. We think that there is no way to fix the arbitrariness that is present in the system. But if South Carolina is not ready to do that, which it seems that South Carolina is not, they should at least fix some of the major systemic flaws by limiting the number of aggravating circumstances to truly narrow the pool to the worst crimes. They should institute a racial justice act like was here in North Carolina for a while to avoid racism in the imposition of the death penalty. And the South Carolina Supreme Court needs to implement a meaningful proportionality review that takes into account life cases as well as death cases.
Thank you.
Thank you.
If I can get the panel back up here. We want to take your questions. We've got a couple of minutes before we need to break for lunch, so we're open to questions. Please. Okay. Well, I had one because, oh, sorry.
Yeah, actually, I was really interested in the point you had about the aggravating factors part. Would another way of getting around that problem being to require increasingly more aggravating factors in every case, in each case, rather than limiting the number?
That is a possibility. We did research. We have information about what aggravating factors were found in all of the cases, and most of them are single aggravating factors. A lot of times it's just like an armed robbery, and that would be one. But also in South Carolina, it might not work because armed robbery often includes a kidnapping because of how South Carolina has defined it. And there's kind of this made-up armed larceny aggravating factor also. There's no actual crime in South Carolina that is called larceny, but oftentimes those will be similar aggravating factors that can be found just based on the fact that there was a robbery. So I think still you would have to limit the number of actual aggravating factors and maybe narrow the definition of some of them. But once that's done, that would be a possibility.
I'd like to add. Please. Yeah, I think one of the major issues is the way these aggravators are written is they do overlap a lot. So oftentimes I would find in Georgia, a prosecutor is not required because they need just find one. They not or have a jury find one. They might just go ahead and charge one, but there could be 4, 5, 6, because of the way they're overlapping. Also, when you have situations, particularly with victims, you could charge the same aggravator multiple times, and that still counts as multiple aggravators. And so again, I think the narrowing issue is extremely important in that regard. There was a study that David Bald was working on before he unfortunately succumbed to cancer in California, and one of the arguments was there was no true narrowing. There have been some other studies before, but under that study, I think close to 90% of homicides were death eligible, according to the statute. And the last thing I'll say is, if you look at the trend of statutes over time, what's happened is it's just been expanding the list of aggravators, right? It hasn't been contracting, it's just been expanding them, because there's very little political cost, right, to legislators in terms of, okay, let's just add more, and again, allowing the prosecutor to have a menu of options.
So you invited a question when you were talking, and that question was the question about the coercive use of a notice, a death penalty notice in the case to coerce a plea. And you talked not only about the morality of that, but also the financial or economic impact of that. And I wonder if you wanted to answer your own question.
Okay, well, thank you for that nice softball question. And so one of the arguments that prosecutors have made, or if they don't directly claim to say, well, I've heard other prosecutors say, is that, well, seeking the death penalty saves money, right? So even if we don't necessarily think this is a case that necessarily warrant a death sentence, right, it will allow us to save money because it will incentivize individuals to take the plea. Okay. Now that's an empirical question, and as an empiricist, I investigated it, and so there's really only been like 2 studies that have tried to really examine the impact of the impact of a death notice on the likelihood of taking a plea. So basically, what I found is, and I think I mentioned quickly, it decreases the likelihood of about by 25% of going to trial. Now, is that enough to offset the occasional capital trial? And the answer is no. And one of the reasons the answer is no is, even if a case pleads, okay, by the time it's played, usually either by statute or by custom, for a case that is noticed for death penalty, you have to have 2 attorneys, 2 qualified attorneys, right? And so there's so much pre-trial or pre-even plea work that goes into that, that the costs just skyrocket. And so I know John mentioned, Professor Downey, you mentioned the $4 million or whatever was that was spent, billion for the executions in California. There's a very comprehensive bipartisan study examining how much more a capital case costs as opposed to a non-capital case. I think the number was around 2 to 3 million. I forget exactly the numbers. This has been replicated in some other jurisdictions. But one of the most conservative estimates is a minimum of about $1 million more, and that's even when you take into account imprisonment cost for life, for a sweaty sentence, the life without the possibility of parole. So again, it doesn't really seem like the savings are there. Sorry for the long-winded answer.
No, appreciate it. Doug Berman had a question.
So this is maybe for Rob or all of you. With the right challenge, and I don't mean to preview what Linda might say this afternoon, to take up what Justice Breyer is suggesting in Glossip is not a categorical challenge to the death penalty across the nation, but specifically in a particular state, right? So that you would pick, or I assume this is part of arguments that will get made in a variety of ways, but is there a sense from any of you, and you've all looked at individual states, and we have Connecticut data also, of which state is the worst on Breyer's criteria?
The worst of the worst?
Yeah, in a sense. There you go. And is that maybe this is more for Rob? Is that the kind of challenge that you think, whatever the strategic value of bringing it that way as opposed to another way, has more chance of garnering 5 votes
Can
eventually?
somebody answer what the worst one is first? Because I want to take in a different direction. Frequently named places are Pennsylvania, California. I think, it's sort of being like, hey, there's this one burning house, but then the one next door has but I think Pennsylvania and California tend to be. I think no is the answer to the question of is that, and so if you look at you need 5 votes, right? And if you look at what's happened over the last, you had a period from, Furman that extended through the 70s where the court really starts managing the death penalty. And then they sort of dismantle it and they do nothing. And then if you look over the last 15 years, you see a line of cases where Justice Kennedy is not only joined on, but really become the champion. He's at the helm of these cases. They run from the death penalty to juvenile life without parole. And then if you look and say, well, it's not only just you have these arc of cases. In these cases, he's somebody who's saying, I don't do case-by-case determination. I don't do is it random? I do is this an excessive punishment? And if the people sort of agreed with that assessment. And then if you say, well, maybe it's just an artifact of the type of cases he's come out, and you're like, was he ever voted on even an extension of an arbitrary discount, a narrowing claim? And the answer is no. He votes with the conservatives on those cases. And then you're like, okay, well, maybe this is just an artifact of death, criminal cases. And you're like, well, actually, if you look at what he's done in the substantive due process context, he's moved the court in the same direction away from this sort of formality to more robust determination. Is it a necessary encroachment on liberty, and have the people debated this? And so it's just so hard for me to believe that if we are going to get that fifth vote, unless the court really changes, that it's going to come in a case that he's never voted on, even in a smaller context, instead of the one where he's been at the helm for over 15 years and has done it across two major areas of law.
All right, well, thank you to the panel. We really appreciate your presentations. I think our next stop is lunch, is that right?
Yes, there should be bags outside, so feel free to...
Great, and we want people back for what time?
1:15, I believe, is the start
Great.
time.
See you all back here at 1:15. Thank you all.